Hello, this is multiple choice questions on legal aspects of business part 3rd. I am Dr. K.K. Mishra from our classes. I have compiled in view of your scheduled examinations to be held very soon. To the questions. The case of Nordenfeld versus Maxim Nordenfeld Company 1904 deals with options are A. Agreement in restraint of legal proceedings, B. Minors agreements, C. Agreement in restraint of trade, D. Agreement in restraint of marriage. Correct option is A. Agreement in restraint of trade. Question number 2. A contract of life insurance is options are A. Contract of indemnity, B. Not a contract of indemnity, C. A wagering agreement, D. A contingent agreement. Correct option is B. A contract of indemnity. Question number 3. An agreement, the meaning of which is not certain, is options are A. Void, B. Voidable, C. Valid, D. Illegal. Correct option is D. Illegal. 4. An agreement to do an impossible act is options are A. Void, B. Voidable, C. Illegal, D. Enforceable under certain circumstances. Correct option is A. Void. Question number 5. Which of the following are wagering agreements? Viewers, let me tell you that all the options highlighted here are the examples. So, complete I am not going to read. This you learn, and wherever you find any one of the highlighted options, you mark them as correct. A. A crossword completion, the prizes of which depend upon correspondence of the computer solution with a previously prepared solution. E. An agreement to buy a ticket for a lottery. F. Commercial transactions if the intention is not to deliver the goods but only to pay the difference. 6. A wagering agreement is options are A. Forbidden by law, B. Immoral, C. Opposed to public policy, D. None of the above. Correct option is B. Forbidden by law. 7. A contract of insurance is a, here correct option is D. Contingent contract. Question number 8. Which of the following are contingent contracts? So here options are A. Contract of insurance, B. Contract of guarantee, C. Contract for the sale of goods on credit, or wagering agreements. Correct option is A. Contract of insurance. Question number 9. Contingent contract is, correct option here is C. Valid. Question number 10. A contract to pay B rupees 10,000 if B's house is burned. This is a excuse me, A. Wagering agreement, B. Void, C. Voidable agreement, D. Contingent contract, or E. Contract of guarantee. Correct option is D. Contingent contract. 11. A agrees to pay B rupees 2,000 if a certain ship does not return at Mumbai port within a year. As promise can be enforced when the ship. Here options are, correct option is B and C both. So wherever you find these, you may mark it correct, that is if it is lost or sunk during the period. 12. Promises forming consideration for each other are known as A. Independent promises, B. Dependent promises, C. Reciprocal promises, D. Mutual promises. Correct option is C. Reciprocal promises. 13. Each party is a promiser and a promisee in case of past consideration, B. Present consideration, C. Every contract, D. Reciprocal promises. Correct option is D. Reciprocal promises. Question number 14. When promisee refuses to accept performance from the promiser who offers to perform, it is options are A. Attempted performance, B. Vicarious performance, C. Tender, D. Frustration of contract. Correct option is A. Attempted performance. Question number 15. Sale of goods for cash is an example of, options are A. Mutual and independent promises, B. Mutual and dependent promises, C. Mutual and concurrent promises, D. Conditional and dependent promises. Correct option is C. Mutual and concurrent promises. 16. When a party to a contract transfers his contractual rights to another, it is known as, here correct option is D. Assignment of contract. I am not reading out for the time constant so the video is not prolonged. So correct option is D in this case. Now question number 17. What the debtor does not expressly intimate, or where the circumstances attending on a payment do not include any intention, the creditor, correct option is A. may apply it to any lawful debt due. 18. When two or more persons have made a joint promise, then unless a contrary intention appears from the contract, all such persons must fulfill the promise. A. Jointly. B. Severally. C. Jointly and severally. D. Jointly or severally. Correct option is A. Jointly. 19. Assignment by operation of law takes place A. By the mutual consent of parties. B. By the will of either party. C. When the subject matter of a contract ceases to exist. D. By the death of a party to a contract. Correct option is D. By the death of a party to a contract. 20. A. Who owes rupees 10,000 to B dies leaving an estate of rupees 6,000. The legal representation of A are here A. Liable for rupees 10,000. B. Liable for rupees 6,000. C. Not liable at all. D. Liable for rupees 3,000. Correct option is B. Liable for rupees 6,000. 21. Owing to a strike in a factory of A, he is not able to supply the goods to B as per terms of the agreement. The agreement in such a case, A is discharged, B is not discharged, C becomes void, D is voidable at the option of A. Correct option is B is not discharged. 22. If a contract contains an undertaking to perform an impossibility, the contract is, correct option is here, void ab initio. 23. An agreement to do an act impossible in itself, it will be always void. So correct option is void. 24. If a new contract is substituted in place of an existing contract, it is called, correct option is novation. C. 25. The case of Taylor versus Caldwell 1883 deals with, correct option is A. Discharge of contract by destruction of the subject matter. 26. A lends rupees 500 to B. He later tells B that he need not pay the amount. The contract is discharged by A. Breach, B. Waiver, C. Novation, D. Performance. Correct option is B. Waiver. 27. A contract has become more difficult of performance due to some uncontemplated events or delays. The contract, correct option is B, is not discharged. 28. Where a contract could not be performed because of the default by a third person on whose work the promisor relied, actually it is not discharged. This is the correct option. So correct option is A. 29. A creditor agrees with his debtor and a third party to accept that third party as his debtor. The contract is discharged by, options are A. Performance, B. Alteration, C. Waiver, D. Remission. Correct option is C. Waiver. Most famous, the Satyavrat Ghosh versus Magni Ram and Company 1954 deals with, correct option is A. Agreement opposed to the public policy. It was all about this tutorial. I hope that you will like it, and if you have liked it, you please do not forget to subscribe and press the bell button. Thank you. Please like, share and subscribe. Thank you very much. Have a nice time. Best of luck.